that accused number 2 was examined by a dentist on the 22nd of June 2020.
Right.
But my lord, that came after the state had re-examined the witness on the contents of exhibit VV1. So basically the boat had already sailed. This morning we reached an agreement, my lord, that to resolve this list between the state and the defense, the dentist will be called in due course.
Yeah, but I have evidence before this court. You can call the dentist, but the evidence I have here is of the report, which is consensual by consent of both parties ended up. Am I?
Yes, section 213, my lord.
Yeah,
even if we did not expressly say so, that was the import of the...
Right, and there was no addendum or any explanation that this document is handed up limited exigency of the date of the 26th of June.
Yes, indeed, that is the position.
Because this was an examination which was prompted, as I understood the evidence, by this witness when he took the accused number 2.
Yes.
Is that not so?
Indeed. In fact, they put it to a witness that the accused did not appear in court on the 22nd of June.
Yeah.
And to buttress their point, they then handed up this document to show that he was examined by a dentist on that day.
Right. And after that, you led evidence about the examination, alleged examination, which was undertaken by this doctor.
Yes, indeed.
But the gravamen of the matter is that that report is before this court. Is that not so, Mr. Ngomezo? Yes, it is before court.
Do I have to make submissions?
No, you have.
Is it the only question the court asked?
No, I'm not asking you. I'm saying, as far as I'm aware, this report is ended up lawfully and it is before this court. That's all.
But my lord, we have made an agreement.
That agreement doesn't bind the judge. You know that. You can agree with Mr. Balui to go to the moon. It doesn't bind this judge. This judge is bound by evidence.
My lord, may I, with your respect, address this case in this manner?
Yes, sir.
The state has submitted that the purpose for handing over the document was for the defense to demonstrate that accused number 2.
The state has argued that.
Just submitted now, confirming what I've used the statement for that reason. The contents of the document was not alluded to.
By whom?
By the defense during cross-examination. We only dealt with the date, which is, I would submit, is the evidence aliunde outside the contents of the document itself, because the defense intended to demonstrate the alibi defense to say when the state alleges that accused number 2 attended court in Shabane on that particular day. So our alibi to that effect is to say accused number 2 was consulted with the dentist. So the contents and everything contained in the docket was never been an issue to be clarified from the witness.
Yeah, so your submission is the document can be headed up holistically to this court, but this court must just peruse a minuscule part of it, the 26th of June. The other information which was elicited by this gentleman, who is the state prosecutor, I must ignore that.
No, my lord, I said, let's look at the nature of the evidence.
Yes.
I submitted that it's evidence aliunde, it's outside the document itself, because it only bears the date, not the contents of what was accused number 2 examined for.
You want us to play the record back? Mr. Baloi led this evidence Where's that document? Let me just look for it. Mr. Baloyi placed the contents of the document on record. Am I correct, sir? Everything.
Indeed.
There's no evidence aliunde. Everything was placed by Mr. Baloyi on record. Let me just get it. He said this witness must read the heading. He read the heading. I remember it's Bafokeng CHC, etc., etc. He even elicited evidence about the number of cavities and the, the dental structure of that your client. He elicited it. So when you say it's aliunde, it can't be correct, sir.
My
Please.
Lord, may I just indicate that
Sorry,
this witness...
wait. Where's the, just give me a copy of that. Because the papers are being messed up. Is that the witness's copy? How much a copy it?
Yes.
Okay, sorry.
Mine has got notes.
No, right, I've got it. For instance, the following evidence was put on record. Complainant, patient requests an examination for oral cavity, dental history, extraction of health questionnaire. Do you present or have you previously suffered from any of the following allergies? Rheumatic fever? No, he put it on record, not me. Venereal disease? No. HIV/AIDS? No. Lung disease? No. TB? No. Are you on medication? No. Smoking? Yes. And then it goes. Rheumatic fever? No. Psychosomatic disturbances? No. Pregnant? No. Viral infection? No. Epilepsy? No. Diabetes? No. Liver, kidney problems? No. Hypertension? No. Asthma? Yes. The patient reports to have been admitted for a heart condition. This is the doctor writing. In 2014 following a mining accident, and it is signed. And Mr. Baloyi also went on the other side and said to this witness, can you put the following information of the clinical examination on record? And he called it a general appraisal. TM joints, lymph nodes, intraoral lips and buccal mucus, oropharynx and tonsils, palate, he even said palate, remember that, floor of mouth, tongue, gingival and periodicum, anal classification, teeth chart, interdental, said it's 11, 22, 23, conlingual recession, 41, 42D. All this information was placed on record. Sir.
My submission.
Yes.
We never agreed with the state in relation to the contents of what is before this lordship. My Lord, that is a copy in the first place. What I've canvassed to the state, I requested to see the original of that document because a copy cannot be handed to the court. Primarily, we want to establish the authenticity of the document. Secondly, if we did not agree on the contents, then the author of the document must be called to testify, to lay the basis upon which he or she made that finding. Number two, the witness concerned, based on the contents of that statement or of that report, cannot explain. He has no medical background. So the person that we as the state agreed to call is because, firstly, when I asked for the original document to compare with that.
But you know what? All this comes now. You never said all of this yesterday when you were leading your client and when you were cross-examining this witness. You never said
My Lord, this thing came after when
yeah, so don't make me like a judge who doesn't listen. Never canvass any of this information. Never. You never did. And now you're canvassing it even without a leaf of this court.
My Lord, may I request that the court incline to our agreement with the state?
But it doesn't bind me, that's what I told you. Can you show me any law which says an agreement between the state binds the court?
No, I don't want to go insofar as that is concerned, my Lord. But with from your assistance as the adjudicator in this matter, if the parties so agree to, as prescribed
I
in terms
have
of
not said I am not allowing the parties to agree to call the doctor. I never said that. Never. You can call the doctor. No. I can't stop the state calling a witness. I don't have that might or capacity in terms of the Criminal Procedure Act. That's why I say, you and him, if you agree on whatever, fine. But I am bound by what was led in evidence in this court. That's all I'm saying.
And my Lord, I wish your Lordship to take cognizance of the fact that I wouldn't be in a position to cross-examine again the witness, because that aspect was raised at the time when the state was examining the witness. We request your indulgence, my Lord, to get the original document first and for the doctor to be called to confirm the contents of what is contained in the dental report.
Is this in pursuance of a fair trial, this application?
That's my submission, my Lord. That would be fair.
Mr. Are you finished? Mr.
I'm done.
Mr. Baloi, there's an application.
As a court, please, my Lord. The defense handed up the document. They approached the state and said, can we hand up this document? And we agreed. And they wanted to use the document which they used, but now that it appears as if it's to their disadvantage, now they want certain portions to be disregarded. It doesn't work that way, my Lord. Once a document has been handed up by agreement, it binds the parties. We submit, my Lord, that the defense cannot now make a volte-face and say, but we only handed the document just for a specific limited purpose.
No, that is not correct, because I was in court, I was listening when you were leading this witness to read what is written on the report.
Yes.
And there was no objection from Mr. Ngobezulu. No objection. Niggies.
In fact, they read part of it in the record.
I know.
Yes. But
anyway, are you opposing that application?
Intimated on the strict basis of the law, my Lord.
You are opposing it?
We oppose it.
Fine. You can call that witness. I don't have a problem. Any response, sir, before I make a ruling? Mr. Ngobezulu? Yes.
My Lord, I stand by my submission.
Fine. Yeah. There's an application by Mr. Ngobezulu on behalf of the applicant, of Mr. Ntansi, accused number 2. And this relates to the fact that after the evidence, which is encapsulated in Exhibit VV1, which was handed up to this court by 2 officers of this court, who told this court that they had agreed to hand it up. And they even agreed that it should be marked Exhibit VV1. And it was duly marked. And this witness was led on the contents of this very document. Cross-examination was conducted by Mr. Ngobezulu in relation to some aspects of this document. Now, this court is seized with this document. The state is opposing the application for the retraction and the recantation of the contents of this document. And Mr. Baloyi says, on a point of law, the state is opposed to that. And I ask pertinently Mr. Ngumezulu well, whether he wants the retraction of this document purely because of the exigencies or the requirements of a fair trial in respect of his client. He says yes. I'd like to differ with Mr. Ngumezulu, and these are the reasons. In the case of the National Director of Public Prosecutions and David Cunningham King, it's case number 86 of 2009. It was an appeal from the judgment of Mr. Busielo, the former clerk of mine, who was in the Supreme Court of Appeals. He wrote the judgment against which there is an appeal. The judges who presided on this application of appeal is Haramse, who was the deputy president of the Supreme Court of Appeals, Nugent, Mlambo, Malan, and Majid. And this is what they have to say about an exigency like this, where evidence is now sought to be recanted when it was formally and lawfully admitted into this court. If you want to read this decision, you can read about it. It's about this billionaire who was avoiding tax, King. And they took him to all the courts, right up to the constitutional courts. This judgment actually landed up in the constitutional court. But it concerns the basis of what is a fair trial. In paragraph 4, the scribe Adams has this to say: it is well to remind ourselves at the outset of a number of basic principles in approaching the matter. Constitutions call for a generous interpretation in order to give full effect to the fundamental rights and freedoms that they create. The right to a fair trial is, by virtue of the introductory words of Section 35(3) of the Bill of Rights, broader than those rights specifically conferred by the fair trial guarantee therein, and embraces a concept of substantive fairness that is not to be equated with what might have passed muster in the past. This does not mean that all existing principles of law have to be jettisoned, nor does it mean that one can attach to the concept of a fair trial any meaning whatever one wishes it to mean. The question remains whether the right asserted is a right that is reasonably required to a fair trial. A generous approach is called for. This is the question for the trial judge, and there is, in general, not an a priori answer to the question whether a trial will be fair or not. Potential prejudice may be rectified during the course of the trial, and the court may make a preliminary ruling depending on how the case unfolds, and may revoke or amend it, like I did yesterday. Irregularities do not lead necessarily to a failure of justice. There is no such thing as perfect justice. A system where an accused person should be shown every scintilla of information that might be useful to his defense. And discovery in criminal cases must always be a compromise. Fairness is not a one-way street, conferring an unlimited right on an accused to demand the most favorable possible treatment, but also requires fairness to the public as represented by the state. This does not mean that the accused's right should be subordinated to the public's interest in the protection and suppression of crime. However, the purpose of a fair trial provision is not to make it impractical to conduct a prosecution. The fair trial right does not mean a predilection for technical niceties and ingenious legal stratagems like here, or to encourage preliminary and pervasive litigation. In this judgment, these 5 judges, senior judges, I must say, they quote the case of S versus Sheikh, 2002, SA 208 cc, at paragraph 43, and the case of State versus Basson, 2003, 3 SA 5H2 Constitutional Court, at paragraph 120. And there is an addendum that an allegation that an interlocutory ruling was wrongly made, which may have a material impact on the outcome of a case like this one, is not sufficient to demonstrate that the trial was unfair. They also cite the case of R versus Corner, 1995, 4 SACR 411, paragraph 139, 185. They also cite the case of Montgomery and His Majesty's Advocate General and another, 2003, 1 AC 641, PC 673. This is a British High Court case of Lords by Lord Hope of Craighead, quoting Pila versus United Kingdom 22, EHRR 391. They also quote the case you read yesterday, Key versus Attorney General, Cape Provincial Division and another, 1996, 4 SA 187 CC, paragraph 13. And they also quote the case of Zuma versus the Director of National Public Prosecutions and others. I've got all the judgments here. I don't have to read them. If you want to read them in adumbration of one I've already read, be my guest. But the application, Mr. Ngomezulu, is not acceded to. It is dismissed. But having said that, you and your colleague, you can call any witness you want. But the application to exclude this evidence, which was formally tendered in this court, is refused because it's not in the interest of justice. And these gentlemen, 5 of them, make it obvious that a right to a fair trial is ambidextrous. It's not only for the accused, it is also for the state and the public, which is represented by the state. Because there's an assumption in South Africa that Section 35(5) applies only to accused persons. No, the corollary, when you understand the law, is that what should happen in Section 35 should also happen in respect of the presentation of the case of the state. It's not a one-way traffic, as they say. Okay, yes, Mr. Badu.
Sergeant Mokhani, counsel for accused number 1 and 2, put the following proposition to you regarding the events on the 18th of October 2020 at the workplace of accused number 2 at Sibanye Stillwater in
18 June.
Yes, 18 June, I'm sorry. Sorry? Oh, I'm sorry, 18 June 2020 at Sibanye Stillwater and Carltonville that after Brigadier Gininda and Sergeant Mohola had departed, you asked accused number 2 for directions back to Rustenburg. He thought that you were satisfied with the explanation that is regarding his whereabouts on the 26th of October 2014, and that you're going to release him.
Mwelele wa molatofatsa wa pele le wa bobedi ba ile ba bolela le lena ba le botsa gore ka di 18 tsa June 2020 be be le mola Sibanye Stillwaters lena ka moraga gore monna Gininda a sepela le mogola lena le ile la botsa molatofatsa wa bobedi tsela ya gore le boela jwang morago go ya Rustenburg ke mo eleng gore molatofatsa yena o be a nagana gore lena le se le khotsofetse ka dilo ka moka tse leng gore le be le di khumane gape le be le tlo molokolla
mele kamsolwa uqala lesibili uthi ngomhla ka-18 kuJune lapha esenza khona umsolo wesibili eSibanye Stillwater eCarltonville uthi emva kokuthi-ke uGininda noSergeant Mohola behambile wena wabuza ukuthi indlela eya eRustenburg ihamba kanjani wase-ke ngaleso sikhathi besicabanga ukuthi ubuziswa ukuthi vele hayi kusonelisekile ngako konke okwenzekile nokuthi-ke emva kwaloko uyomkhulula.
Your response was, when we left the mine yard, we had evidence that accused number 2 was not at work and that you parked outside the premises and he had a conversation with Brigadier Gininda.
karabo ya lena le gestše le tšwa mona merafong lena besše lena le botlhatsi ba gore molatofatša wa bobedi o be a se mmerekong gape lena le be le pakile ka ntle.
Kuthiwa-ke lapho-ke masele nililisekile umsotho wesibili wayengekho emsebenzini ngalelo langa nase ninaye niphaka ngaphandle uBrigadier Gininda wasekhuluma naye.
Now, except for the cloaking records of accused number 2, was there anything else that was shown to him by Brigadier Gininda?
Biale ka ntleng ga di record tšela tša ge tša go tloka tša molatofatša wa bobedi go na le dilo tše dingwe tše e leng gore mohlomong lephodisa Gininda le ile la mmontšha tšona.
Ngaphandle kwamarekhodi okutloka emsebenzini khona uGininda amphodisa khona umsolo.
Gopola lena from our side.
Are you referring from our side?
Yes.
Sana moncha no ready to know village fela ka
I do not want to respond on what I do not remember correctly on what happened.
Just to rephrase, you mentioned an identity kit. When did that where did that incident take place regarding the identity kit?
Go le gopotsa lena le la bolela ka identity kit. Taba ye we e be e diragetse ning.
Kukhulume nge-identity kit loko kwenzeka nini?
Okay, gopola bela la bola re le ka mo ntle ga mine before the close mine.
Now I remember, my lord, that happened whilst we were outside the mine before we left.
Ngiyakhumbula manje lokwenza ngaphandle kwamayini singahambi.
So when accused number 2 approached, or when accused number 2 indicated that he wishes to speak to Brigadier Gininda, that was after the cloaking records had been consulted and this ID kit shown to him.
Molatofatšwa wa bobedi yena o be a rile o kgopela go bolela le ntate Kiminda ka morago ga gore the setse ba mmontšhitše di-clocking record le ID ntho we yena kit yela. It is correctly so, my lord.
Manje umsolwa-ke semuva ukuthi-ke kweneliseke ukuthi bamkhombise ama-clocking record akhe baphinde bamkhombise-ke nale-identity kit.
Now, regarding the events of the 19th of June 2020, the day on which accused number 2 made a confession to Lieutenant Colonel Rapadio at Morocco Police Station.
Jwale ditaba tša di 19 tša June 2020 ge ne molatofatšwa a ilo bolela a ilo ke bolela mo pele ga lephodisa kwa Morocco Police Station.
Well, because in 19 of June,
It was put to you that you were traveling in a Toyota Fortuner.
Lena ba ile ba le botša gore le be le sepela ka Toyota Fortuner. That is correct.
Do you remember its registration number?
Le sa gopola gore number plate ya yona e be e reng?
FV
FV
47 LRGP.
LRGP, my lord.
The number plate FB47 LRGP.
Do you know if this vehicle is fitted with a tracking device?
Le a tseba gore koloi eo e be e loketswe tracker na?
Rena re bitsa AVL.
Yes, and we refer to it as AVL.
What does AVL stand for?
Ye emerging AVL le bolelang ka yona.
Automatic vehicle location.
Automatic vehicle location, my lord.
Automatic vehicle location.
And what purpose does it serve?
E šoma go dira eng?
E kgona gore tšireletša gape le gore bontšha ona re sepela kae le kae re dira mošomo wa rena.
It is able to protect us and to also direct us on where are we driving as we are conducting our duties. And the witness would still like to proceed, my lord.
And gape le go bontšha koloi le gore ya botsuiwa re kgona le go e lebelela ka yona AVL.
And to also show if the vehicle is to be stolen, we are also able to see through the AVL.
Now, counsel for accused number 1 and 2 put it to you that on your way to Morocco Police Station, you took a detour and stopped at a filling station near Alberton, where accused number 2 was assaulted. Will this be reflected in the records of the AVL?
Jwale moleledi wa molatofatšwa wa bobedi yena o rile ge ntše le sepela le ya Morocco Police Station lena le ile la fapoga la tsena mo e leng gore le be le ile tšhela petrol gona mo Albertine mo la petrol station mo molatofatšwa a ileng a bethwa seo se tla kgona go bontšhana mo yona AVL yena.
In other words, if there was a deviation in the route that you had to follow, would that be reflected in the AVL records?
Mola ge le na le tswile tseleng e be le swanetše le e latetše e tla kgona go bontšha go yona AVL yeo.
Manje tjona ngesikhathini ya eMorocco nathi sisuka nahamba naye endaweni yase-Alberton naseGarage afika umsola waphi noshawa khona manje umbuzo uthi-ke loba kuzokhombisa yini kule AVL yethu.
Itla bontšha.
Yes, it would reflect, my lord.
Yebo izokhombisa.
Yes. It was put to you that when you deviated and stopped at a filling station, accused 2 was taken out of the Toyota Fortuner and brought to Mr. Jonathan's vehicle, that he was made to sit on the right side of Mr. Jonathan's vehicle, and Sergeant Mabena was on the left and Buthelezi was on the right at the back. and that Sergeant Mabena used a silver-colored two-weights plastic to suffocate the accused, and that Buthelezi was blocking accused number 2 from leaving the motor vehicle, and that the accused was assaulted, and that you moved away from that place after this assault to a dumping place near Alberton at an industrial area.
Kitaba e telele ye mo eleng gore ba re molatofatswa o ile a ntshiwa ka koloing ela ebe le sepela le yena ka go yona a lokelwa ka koloing e leng gore ebe e na le Jonathan le Mabena le Buthelezi yena a lokelwa ka leska ka seatleng sa go ja mo eleng gore Mabena yena o ba le ka seatleng sa lenyene Buthelezi yena a tšea plastiki ya Truworths a lokela molatofatswa sefatlhogong ke mo eleng gore o ile a bethwa ka moraga mowe le ile la tloga la ya mola mo go latlhiwang dilo gona.
In other ways, that the accused was assaulted in your presence.
Se se bolelang gore molatofatswa o bethilwe lena le le gona. Even today, my lord, I'm still declining that never happened.
Okay, umsolo wethu kisho motweni yakho esomotweni ehamba uJonathan uMabena wayekhona ngaphakathi noButhelezi uMabuthelezi wakhipha iplastic yakhe le ayifaka ekhanda likaMsolo and futhi ke uthiwa uMabena yena wemvalele ngale kumnyango ukuthi angakwazi ukuphuma and kuthiwa kwaqhubeka ukhawa khona uMsolo lapho waphila.
And there at the dumping place on the way to Alberton, that the accused was handcuffed to a steel pipe. He was further assaulted.
Gape ba re molatofatswa mola mo go latlhiwang dilo gona ke mo eleng gore molatofatswa o ile a bethwa ka pipe ya chipi.
And later on that Brigadier Gilinda arrived, but it was put to you that you did not participate in the assault there at the garage or the steel place. It was put to you that you moved away when the accused was assaulted. You came back there at the steel place and said they must stop assaulting the accused. It was put to you that the words were used is yekelani demand.
Bare ge ke mo eleng gore lena bare ga seng ke lebe karolo ya go betha moisaoki gape go ile go tswelwa pele a bethwa go fitlhella lena le be le botswa mantswe a gore lesang moisaoki.
Was the accused ever assaulted in your presence there at, as alleged by the defense, at this steel place?
Molatofatswa o ile a bethwa na lena le le gona mola mo tulong ela ya ditšhipi. I do not recall him being assaulted.
Umsolo wathathwa endaweni okulapha khona uDuty wafika wabushela ensimbini lapho kuthiwa uBrigadier Gilinda naye weza lapho kuthiwa wena akawuzange ubeke isandla khona lapho wena wasuka wahamba wathi wasala washawa wena wathi usubuya-ke wena wathi yekelani demand wathi cha kwenzeka.
And that from that point, it was put to you by Counsel for Accused 1 and 2 that you proceeded to Chris Hani Baragwanath Hospital, pick up Colonel Rapadu, and went to a dumping place in Orlando where there were disused machines where the accused was further assaulted in your presence.
Gape ba re go tloga mo ke mo eleng gore lena le ile la ya sepetleleng sa Baragwana ke mo eleng gore le ile la tšea lephodisa Rapadu gape la tswela pele la ya Orlando ke mo eleng gore molatofatswa o ile a bethwa gape le ntse le le gona.
Now
kuthiwa ke lapho wena asuka nesibhedlela sase-Baragwana Baragwana lana thathwa khona uKoloneli Rapadu naye kule ndawo ekulethwa khona iDuty ngase-Orlando la waqhubeka khona washaya umsolo.
Now, were there any charges laid that an assault took place in your presence and that you failed to stop such an assault?
Go na le melato e leng gore ile ya bulwa na ya gore motho o bethilwe le le gona lena le paletswe ke gore le thibe ge be motho a bethwa.
Manje khona icala yini lavula lokuthi wena ukhona isikhathi eshaya umsolo?
Awu.
No.
Alikho.
or any disciplinary proceedings put in train for the fact that you failed to stop an assault in your presence?
goba motlhomong merato e tšerweng mmerekong ya gore lena le paletswe ke go thiba motho a bethwa
nokuthi khona inyathelo ezathathwa emsebenzini wakho ukuthi wena awuzange ugweme ushawa kukamsolo?
Awa.
no
Cha, akukho lo.
You mentioned further in cross-examination by counsel for accused number 1 and 2 that you did arrange escort on the day, the 19th of June, 2020. Now, what is the position when you are being escorted? Are you allowed to deviate from the route?
jwatše lena le ile la re ka di 19 tša June le ile la kgopela gore le tle le be le batho ba ileng gore ba sepela le lena ba le lateletše jwatše motšhotšhisi o nyaka go tseba gore le dumelletšwe na gore le fapoge tseleng ge le na le batho ba ileng gore ba sepela le lena ba le latelela ka morago
Antsho bani labantu abanitindezelayo niyavunyelwa yini ukuthi niphezuke endleleni?
Awa.
no we are not allowed to deviate my lord
Cha, asivunyelwanga. My Lord, may I request a comfort plea?
Yep. Are you proficient? Oh, Mr. Jonas is all right.
As a court, please, my lord, the state is going to canvass the AVL report with the witness. The copies were given to the defense on Friday when we received the report, my lord.
Wait. You say there is a report.
Yes.
What you call it? What? An AV?
It's an AVL report, automatic vehicle location report, that shows the movement of the vehicle in question.
Sort of a tachograph.
Indeed, my lord.
But you say you have a report. Has it been disputed?
Well, it was handed to the defense on Friday. They haven't really indicated what their position is.
No, they must indicate, because as I recall, evidence of a technical nature requires an expert to adduce that evidence. You can lead that evidence through this.
Yes.
But if you say it's a report of a mechanical device, are you going to call the expert?
Well, it just shows the location.
Oh, okay, fine. Okay.
Yes.
But is it being disputed by Mr. Ngomezulu? Are you objecting?
I'm objecting, my lord.
Right. Mr. Munisi, are you objecting?
I'm just receiving it now. Maybe 30 seconds ago.
30 seconds ago.
Yeah.
Mr. Ngumalo,
My lord, it is evidence
10 seconds ago.
It is evidence of a technical nature. I don't understand what is written here.
Technical.
Yeah, it's true.
You have never heard of evidence of a technical. I don't charge much for classes, you know.
Yeah, it's technical. I don't understand, my lord, what is written.
Okay, fine. What do we do if they say they want to prepare and they are opposing, and you want to canvass it with this witness?
As a court, please, my lord, I personally brought this document to the defense on Friday.
No, Mr. Munisiare.
The
Sorry,
court,
30 seconds ago.
the court will recall we adjourned early on Friday. I personally came to court, gave each counsel a copy of the report. They were consulting here with the accused.
So they got the report on Friday.
Yes. Immediately when we received it, my lord, we shared it with the. I brought it personally to them here in court.
My lord, may I just make the following submission? During examination, Chief, this evidence was not led.
Yes, I'm aware of that.
Yes. Now the state wants to reintroduce new evidence.
Yes.
I believe it's not going to be fair, because we must also cross-examine the witness. That is, the state wants to reopen for us to cross-examine. Because
Yeah.
admit the contents.
Yeah, he's going to. He knows it. He knows the law. He's going to bring an application. So what do you intend doing, Mr. Baloyi?
As the court please, my lord, it was put to Sergeant Mokhani in cross-examination that he took a detour. Stop over at the filling station, stop over at an industrial area in Germiston, stop over at Chris Sani Baragwana Hospital, and also stop over at Orlando, where there were disused machines. They put it to the witness that he was using a Toyota Fortuner. The witness has just testified that it's fitted with a tracking device. And if there's objective evidence, my lord, that can assist in the resolution of this issue, and we must mention that it's something that cropped up in cross-examination, that the witness deviated from the route. We submit, my lord, that if there's objective evidence that can help to resolve the issue, that evidence should be allowed.
Are you ready to argue the contrary, all counsels? Or do you want to prepare? Let's start with Mr. Mgomezo. There's an application. Do you want to prepare to oppose it, or what is the position?
We have, my lord, I'm not ready at the moment.
You have to prepare.
I want to prepare, but before I give another counsel, I need some clarity in terms of what the state has just informed the court or submitted to the court about this piece of evidence on the route that the defense suggested that they were taken from that filling station up to Orlando.
Yeah, they stopped, according to the version, if I recall it, they stopped next to a filling station. In Alberton, there's a board which says Alberton, there's a filling station. Then the accused two was then transferred into Jonathan's car, placed on the back. He maneuvered the seat to injure his ankles. Mabena was on the right, that evidence. And after that, the convoy left to a dumping place where there are still piping. The beating continued, and thereafter, during that beating, one of the handcuffs of the accused two was loosened, and he was connected to a pipe and beaten again. And after that, the convoy left towards Orlando. Baragwana, Orlando, then there was beating in the dumping place. Now this gentleman says he's got evidence to counter that. Are you saying that's it? Hello?
Indeed, my lord.
That's what he says. He says he's got a tachograph. He calls it an AVL.
My lord, the purpose for bringing this application is to rebut the version of accused number 2. But the whole issue about the movement of this witness and Mr. Mabena did not start at the cross-examination.
No, fine.
It started at examination in chief.
Yeah, fine.
Where this witness and Mr. Mabena drove to Pukeng. That's the evidence of the destination that they are going to reach. But there were movement that were mentioned by the state during examination chief.
Mr. Gomezo, you are a seasoned lawyer. He wants to introduce new evidence.
That's correct.
And if you are going to object to it, tell me. You want to prepare or you object to it now? So too, Mr. Mnisil and Numalo and accused number 5 counsel.
Can you prepare, my lord, to make submissions? I'm not ready now.
Until when? Until when? When do you want to make?
Maybe we can proceed after lunch. It's not going to be much.
Mr. Mnisil?
Well, I've got the following submission to make. It will be noted that apparently, I'm not so sure to what extent this also have an impact on accused number 3.
I don't know.
Yes. The reason why I'm saying this is almost 5 minutes that have been handed to this document. The state says it handed to us on a Friday, but I'm receiving it now 5 minutes ago. As an officer of the court, maybe there's something that I can pick from the document that I can assist the court.
Yes.
But if it has been handed to me 5 minutes ago, I'm not in a position to do that because I haven't gone through the document.
How long do you need, Mr. Menezes?
I don't know, my lord, what this document consists of and my analysis of it, where I
Mr. Mgomezulari is just an easy document. ABC.
maybe
Lunchtime, we shoot.
maybe here an advantage of going through it, you see, because it does not seem from, I mean, it does not match from Mr. Mgomezulu.
So you need how many- how many-
On the base of the document.
How much time do you need?
Let's try after lunch now. I would go with what
Mr. Ngubalo?
was saying.
I also propose that we start after lunch.
What's the time now?
Please, my lord, if I can make this proposal, maybe we can let this witness stand down until tomorrow. There's a short witness who's waiting outside. Maybe we can then proceed with that witness in the meantime,
Okay.
and then adjourn after that.
You want to properly formulate an application.
Well,
I've listened to you, I've heard you.
yes,
But for record purposes,
we can simply amplify that.
yeah, me, I prefer written submissions so that you can't say, yesterday he didn't say this, he said it when Mandela was still president. If there's a record, then you are able to say, here's the record. So are you going to prepare some short hits?
Yes.
All of you, some short hits.
Yes,
That's all.
Until when, madam?
Then we can do it tomorrow because he says there's another witness, a short witness. So you can bring the application tomorrow, fully formulated, and then you also you can bring your responses fully formulated tomorrow. Because you are saying you want to come back at 2 o'clock, meaning that you don't want to take a lunch hour. Is that what you're saying, Mr. Newman?
No, that is not what I was saying.
So how many minutes do you have between now and 1 o'clock? How
Yeah,
many?
if we have to prepare ahead,
How
I
do-
think
yeah, how many minutes do you have? What's the time now?
it's 11:10.
So you have 1 hour, 50 minutes.
1 hour, 15 minutes. So
To
I think it
prepare.
will be short. If we have to prepare it, I propose that maybe we adjourn until tomorrow.
Yeah, tomorrow then.
Yes,
Okay.
thank you.
Okay, the application and its objections by councils will be heard tomorrow morning at 10. You are excused until then, Mr. Mafane.
Ntate Mogwane, go na le kgopelo e santseng ba e dire jwa tse swanetse ba ilo lokisha dipampiri ke ka mo e leng gore kgoro e re lena le a lokollwa le tlo boya gape go sasa le tlo tswela pele ka moraga gore ba dirile kgopelo ya bona le a kwešiša well understood by the witness, my lord, and he says he will be present tomorrow.
kunalo udaba ke ofishane oluzolungiswa-ke mayela nale ncwadi emayelana nokuthi le moto babehamba ngayo yahamba miphi imizila noma yayihamba kanjani ngaleya langa abameli-ke bathi banenkinga naloko banikezwa-ke isikhathi ukuthi bakulungiseleke lokho ukuze kube kusasa ufakazi lona uzodedelwa-ke na umshushisi usunayo nje ufakazi ozothatha isikhathi esincane ekungaqhutshekwa ngayo yena-ke ubaba umkhwana uzobuya kusasa.
Yes, Mr. Mgomezulu?
My lord, may I request your lordship to remind the witness before he leaves about the dockets that we requested him to bring.
The dockets, eh?
The docket.
Do you remember?
Le sa di gopola? Yes, I remember, my lord.
Ngiyawakhumbula-ke amadokote
He remembers.
ukuthi ngize nawo.
Mr. Baloyi, in the meantime, you must mark the report by the sergeant for court purposes.
Yes, it's already been marked exhibit MM in brackets 2, my lord.
You never marked it for mine. Did you mark? Did I mark mine? No, I don't have. Actually, me, I don't have. The very person who authorized that the report should be made, I don't have a copy, even now.
Yes, if my learned friends don't have a objection, we can hand it up now, my lord.
No, why would they object? It's in the record. I expunged that ruling I made. I revoked it.
So is the court referring to the information?
Yeah, the information which the sergeant marked confidential.
Okay. So
It's not the one.
No, this
You
is
see,
something
we're
else.
talking at cross purposes.
Yes, I'm sorry, my lord.
Where's that information? Okay,
But it
just
has already
remember,
been marked, my lord.
I need it. You say it's marked MM,
No, not this one. I think it's already marked.
already marked? What?
Exhibit WW.
Exhibit WW.
Yes, my lord.
Okay. Okay, ntate, tla bana ka hosane.
Go lokile, ne?
Tomorrow then.
Leloko la John.
Sorry, were you ever a boxer?
Ba re salla ba Ramatswetse. I used to train when I was in school, my lord.
Okay. Is that document?
In the meantime, I'm waiting for a comfortable break. A comfort break. Just
Comfort
5
break.
minutes. Yes.
Where is your witness now?
He must be outside.
Yeah. Now you can go. Comfort break. How long? How long, sir?
I'm told it's already.
Oh, it's a
ultimately that we can take a shot.
short agenda. Okay. Okay, 15 minutes is okay.